Thanks, Mark, for the great song. So there is something very perverse about so many medics giving so much praise to a lawyer. There will be very few times we'll see this, but I think once you see the dedication, the amount of detail that Luke's added to this, you'll see exactly why you're hearing so many of us say that so many people have been involved, but without Luke and Shannon and the people from Holland Payne, we wouldn't be here today. So, Luke, thank you, and take the stage.
Thanks, John. Thank you again for having me. It has been, to be frank, an exceptionally tough negotiation over the last 2 months. It's been very difficult, and it's been particularly difficult for the SMOs and VMOs on the task force, because they've really had their head on the chopping block throughout these negotiations, and they've done an absolutely amazing job. It's been a pleasure taking instructions from them. I thought I might just start by putting a little bit of perspective. I'll be brief, it's been said already, but when we first had these contracts offered to us, they constituted an absolutely radical change to your employment conditions. You had no protection from unfair dismissal, no dispute resolution, no collective bargaining. Your clinical autonomy and your ability to advocate for your patients was compromised. And the contracts provided for, to use Dr. Davis's words, unfettered managerial power in respect of all aspects of your work. And in January, the government said quite clearly the contracts would take it or leave it. There would be no changes to the contract, no legislative changes, and they were refusing to negotiate, and that's when the campaign really kicked into gear. We were successful in achieving all, or at least most of our objectives in this campaign. We got legislative change. We got changes to unfortunately we couldn't get changes to the Industrial Relations Act. That was a bridge too far on these negotiations, but we got significant changes to the Hospital and Health Boards Act. Firstly, a change to Section 51, subsection 3, which provides that a health employment directive which is inconsistent with your contract, well, the contract prevails in those circumstances. And you will recall that initially there was some caveats on that in respect of regulations providing otherwise, and therefore allowing them to issue regulations which could override contracts. We hammered them on that, and as a consequence of that, literally overnight, a new amendment to the Hospital and Health Boards Act was introduced just as it went to Parliament, which was to introduce Section 65B, which provided that employment regulations cannot override the contract. Now, employment regulations were defined to mean the two regulatory making powers that we had criticised the government for keeping to themselves. So that was an exceptionally good outcome. They were absolutely adamant at the beginning of negotiations in March they would not do this. It was absolute anathema to them, and the campaign was successful in doing that and giving you protections, which means that directives which are inconsistent with the terms of your contract cannot be issued. Now, of course, directives which aren't inconsistent with your contract and deal with topics which are not covered by your contract can still be issued, and that has been demonstrated by some of the directives I'll talk about later tonight. But it is still a very substantial protection. We have substantially curtailed the government's legislative and policy-making powers by these amendments to the Act, and all of you who have been involved in this campaign should be very proud of that. I'm going to start going through in detail the contractual provisions which I think are relevant. We have obviously been highly critical of the extremely and deeply flawed addendum. That really was a, be frank, legally unusual proposal which arose solely from the government's recalcitrance in actually amending and fixing the contract which they'd stuffed up in the beginning. Now, we've had some extremely significant wins in clawing back some of our previous conditions when the addendum was consolidated into the contract. So, as you were all aware last week, I think it was last week, it's all a bit vague now given how many hours a day the task force are doing on this, but they decided that they would put the addendum into the contract. Now, there is contracts which we printed off tonight for people to look at. There are track changes in those contracts. They don't necessarily reflect all the changes that we've managed to obtain in the last week, because that's been a movable feast in terms of negotiations. But we've got back the requirement for the service to consult with you in respect of relocation. The original provision did not require them to do so. We've changed the the way that your ability to raise objections works. Now you can raise, provided you can establish reasonable grounds, you can refuse relocation direction. If ultimately you are made to relocate, they must give you reasonable notice of that. Okay, and that is a term which has some legal significance because it's linked to the nature of the relocation. Obviously, if you moved from Cooktown to the Torres Strait, that's going to take a long time to actually effect, so that will be a long period of notice. If you're being moved across the street, obviously not the same. But more importantly, if you cannot reach agreement with your service in respect of relocation, you have the ability to access arbitration by a Deputy President of the Queensland Industrial Relations Commission. Okay, and I'll get on to dispute resolution shortly. Perhaps crucially in the issues raised with me by senior doctors across the state has been the attack on the clinical autonomy of doctors and their ability to advocate for patients. We've had some significant victories in negotiating a number of clauses of the contract which are linked to that. Firstly, as Howe mentioned before, profitability, viability and reputation as a basis for summarily terminating your employment has been entirely deleted. That is important because although in very serious circumstances where you do engage in conduct that does that, it could constitute serious misconduct. When you start defining serious misconduct like that, the practical effect of that is it becomes much easier for a service to raise as an issue to terminate your employment. So that's a significant victory getting rid of that. In respect of the linking of clinical autonomy to the services of the policy, which was in Clause 6.2 previously, we've had that provision deleted. So that is a significant and I think a very good win for doctors in this process. This is perhaps, I'll move on to dispute resolution, which is in Clause 9 of the contract. It's probably one of the most significant outcomes of this campaign. At the beginning of the campaign, you had no dispute resolution. In fact, on the 1st of December last year, they took that away from you when they passed a regulation making you high income positions. We have got that back. You have a contractual right now under the new Clause 9(2) sub E to, in the event of a dispute or grievance, progress that to an arbitration before the Deputy President of the Queensland Industrial Relations Commission. Now, you might recall previously there was also reference to appropriately qualified person. We've got rid of that. It now must be a DP or their delegate, which means a Commissioner of the QIRC. Now, we were highly critical of the complete absence of any definition of the powers and processes that are available to the person arbitrating a dispute. If you look at the dispute and grievance resolution procedure, which some of you may have, it was outside before, that process that's in there is reflective of the dispute resolution process in the Industrial Relations Act. So you have the ability to file a notification of dispute setting out your case. They respond. You have the ability to call witnesses. You have the ability to call expert witnesses. You have the ability to file submissions in respect of your dispute. It is a process which is essentially analogous to what exists under the Industrial Relations Act. And that is significant, and it's significant for these reasons. It's not just the clauses that I've spoken about in the addendum which refer to arbitration, which you can utilise this clause to access. It is any workplace issue. It is any contractual dispute. So any workplace issue. Now, I'll give you an example of why that's useful. You may have a colleague who is being relocated. Their ability to dispute that relocation is prescribed in the contract to personal circumstances. However, you may be concerned that given their particular expertise, that will have a significant impact on your team. You can use the dispute resolution process to support your colleague who is objecting to their relocation by running your own dispute about the difficulties that that relocation will have. So this is a very significant clause. It opens up your ability to dispute any matter raised in your employment, and this links into the concerns we've had about them compromising and attacking our clinical autonomy and patient advocacy, because you can raise disputes about that. So that is a significant win that we've had in this campaign. Now, remuneration, we've banged on and on in our communications about the fact that this was one of the internal provisions of the contract which allowed unilateral variation by the service. We have been successful in changing the contract to provide that your Tier 4 remuneration, you'll recall that there are aspects of that which are linked to a term, 1, 2, 3, 4, 5 years, or perpetual. for the period of the agreed term, they cannot vary that any longer. They could previously. So that's a good win as well. And if you've got the option for perpetual, insist on it. The next issue was hours of work, and as Howe said, we've had, again, significant movement on this. They are now required, as they were not before, to consult with you and to consult with your colleagues when they propose a change to rosters or the introduction of a new shift. Now, you can refuse to do that new roster if you can establish reasonable grounds, and those reasonable grounds, as Howe said, are, and there's some examples for those, but they include things such as the impact it may have on your junior doctors. I mean, there's been an example given to me in one hospital where they decided it would be a good idea to put the consultants on day shift and the juniors on night shift. It's a profoundly stupid decision, but you can challenge that through this process. And reasonable notice, again, must be given, and it must be at least 4 weeks. And again, arbitration is an option. I won't go through review of KPIs. Suffice to say that one of the significant wins we had, which Howe has addressed this, but one of the significant wins we had was, you will recall, the addendum provided that the moratorium on KPIs affecting your remuneration only applied to contracts which were entered into by the 7th of July. We've got rid of that, so that SMOs that come on board after that date will have the same terms in their contract as well. So we protected new SMOs that are coming in after the current contracts are issued. Intellectual property, the addendum has been scrapped. It was always something which we never quite understood what they were doing there. It certainly didn't meet what we were complaining about, and ultimately they've understood what we were complaining about, and they have clarified that they only are able to have a proprietal right to intellectual property that you create, which is created as a consequence of the duties you perform. Now, the example which I used in negotiations was this: you're a cardiac surgeon, you do aortic dissections all day, that's all you do. You've got no duty to invent, not engaged in research or anything like that at all. You go in, you operate, you go home. You're on the beach on your holidays and you think of a wonderful new way of doing a St Jude's valve, and you decide that you're going to patent that and produce it. Under the contract previously, they would have owned that. Under the contract as we've now negotiated, they do not. That's a good win. And this is perhaps the most, up with arbitration of disputes, one of the most significant victories we've had in this campaign. You had no unfair dismissal rights as of 1 December last year. The addendum did not provide you unfair dismissal rights. It was, as you would know, heavily criticised by us for lacking any references to powers, to process, or even to the remedy that you'd get if you decided to dispute a termination, the fact it wouldn't apply to serious misconduct. All those issues have been dealt with, and we have a new provision inserted into the contract, which is up on the PowerPoint, which is that when a Deputy President of the QRC is conducting an unfair dismissal review or arbitration, as it now is, in conducting that appeal, the arbitrator must apply the procedures applicable to a claim made under Section 73(1)A of the Industrial Relations Act. That is the actual provision which in the legislation which stripped you of your unfair dismissal provisions that they rights they referred to. We have that in the contract. You are now in the unique position, I would think, in Australia of being one of the only workforces that actually has a contractual right to an unfair dismissal remedy. So that's a huge win. In respect of professional development leave, obviously we were all concerned about the fact that they could direct us to undertake during our professional development leave courses which were not necessarily part of our professional development. So fire safety training, workplace health and safety stuff, issues relating to management, things that we were just not interested in doing as part of our own professional development. We've confined the application of that clause to them only being able to do so where it's to address or improve performance issues that have been identified during your PAD each year. I won't spend much time on reversion because I think it was a pointless addendum that they incorporated. Anyone who goes on contract was never ever going to go back to the mocker and lose PPA. But we, for purely political reasons, made sure that they at least referenced the industrial instruments they were taking away from us in the clause. And clause 32 previously provided that any variation that is not specifically contemplated by the contract may only be made by written agreement. I apologise for the typos in that, but the struck out thing is the stuff that we've had removed. So, as you know, these things are being implemented by HED. There's going to be a number of HEDs issued, the Contract Advisory Committee, which I'll come to, the VMO contract and contractual framework, which will also have the dispute resolution procedure attached, similarly for SMOs, and there will be a HED issued to continued private practice arrangements up until the new contract implementation date of 4 August. Now, the CAC, and I don't refer to it as anything other than the CAC anymore, it's a committee of 9 members, including an independent non-voting chair. The DG appoints 3 HHS representatives, the DG appoints the independent chair, and the DG appoints a departmental rep. So 5 of the members of the committee are appointed by the DG. There are 4 employee reps that will be voted upon by you, 1 Metro rep, 1 VMO rep, 1 remote and rural rep, and 1 regional rep. This is ultimately the compromise we had to reach to get something else, which I'm going to come to in a second. You guys elect them. They have 3-year terms, and casual vacancies are filled by either a re-election in the first 2 years or a count back in the last year. The purpose is to provide advice to the DG in respect of implementation and strategic review of the contract. And decision-making by the committee has to be by consensus in respect of all matters bar remuneration and certain allowances. In respect of all those other matters aside from remuneration, if consensus can't be reached, then the chair must appoint an independent reviewer, and the independent reviewer will make a recommendation binding on the committee, which will be submitted to the DG. What does the DG have to do then? Well, the DG can elect to accept it, or the DG can elect to reject it. The DG can elect to send it back to the committee and say, I have these concerns with it or want further information on it, come back to me with another recommendation. Or he can just reject it, but he must provide written reasons for it. Okay? That's about the best we can do there. In respect of remuneration, we've had perhaps the most significant win of the campaign so far, with a government who is absolutely determined not to allow collective bargaining of any kind whatsoever. We, in the very dying hours on Friday night, and with a few stutters and heart attacks in recent days, managed to get an agreement from government that they would allow independent and binding arbitration in respect of remuneration base rates for SMOs and VMO classification levels, professional development allowance, and the inaccessibility incentive. Now that's important because obviously your base rate, if that goes up, so do your tiers. So that has that impact flowing through. Arbitration is engaged in 2 circumstances. One, if the committee does reach a consensus on this, which I think is probably unlikely, given that there is, half the committee is employer reps who take that direction from the DG, but say it happened. Then if the DG rejected that, it would go to arbitration. If, however, the committee cannot reach a consensus, it must go to arbitration at that stage, and the arbitration procedure that they must follow is the grievance and dispute resolution procedure, which has been circulated tonight, which provides for that process there. So it's a process which is analogous to the arbitration process now for wages, and that is an absolutely enormous win for the doctors that were negotiating on your behalf in the task force, because they were passionately, I think that's an appropriate word, passionately against allowing this to ever occur for doctors again. And it's because of your campaign that we got them to do that. Well, as I said, we've achieved contract changes, legislative changes, and new HEDs, which are beneficial to us, which the government told us that they were not going to be agreeable to in January. It's not what you had on the 30th of November last year. I'm sorry, but we couldn't get that back. But it's not what they offered you in January. And what we've presented to you tonight is substantially and significantly better than that. What this process, I hope, has taught you all, and what the processes that they've put in place through things such as the CAC and also the robust arbitration process what we have now, is that you must act collegiately and collectively in dealing with issues in your workplace. We don't have the old mechanisms which allowed us to have an equal bargaining relationship with our employer through the IR Act. We don't have that anymore, so we need to make sure that we continue to act collectively and collegiately to address workplace issues. And it's unsurprising that as a union lawyer, I suggest that you join your union. I think this campaign has demonstrated why that's important. That's all I have to say. Thank you.